Welcome to NeLI Pod, the official podcast of the National eDiscovery Leadership Institute. Hi, I'm Daniel Gold, your co-host and navigator through the evolving landscape of eDiscovery.
And my name is Brandon Mack. I'm the co-host of our podcast. Our guests, from judges to eDiscovery professionals, share insights that cater to all experience levels.
Whether you're looking for a broad overview or in-depth technical analysis, this podcast is your gateway to understanding and implementing effective eDiscovery practices.
It's important to note the opinions expressed on this podcast are those of the individual guests and the host, and do not necessarily represent the views of their respective employers.
We're here because of our passion for eDiscovery and our commitment to providing free, accessible educational content to legal professionals everywhere. And welcome to the NeLI Pod, where we explore the intersection of law, technology, and practical discovery solutions. I'm Daniel Gold, here with my co-host, Brandon Mack. And today we are speaking with Chief Magistrate Judge Young Kim of the Northern District of Illinois. Judge Kim brings a unique perspective shaped by his journey from Cook County Public Defender to Assistant United States Attorney to EEOC Administrative Law Judge before his appointment to the federal bench in 2010, where he made history as the first Asian American appointed to the federal bench in the Seventh Circuit. His judicial opinions have provided crucial guidance on pressing electronic discovery issues, from TAR workflows to production organization requirements. There isn't a topic I believe that Judge Kim hasn't covered that has had some impact in a positive way on the entire eDiscovery and the legal profession. Today, we're going to explore how judicial philosophy meets technical reality, where the boundaries of reasonable discovery lie, and what the future holds as new discovery technologies continue to shape our field. Judge Kim, thank you so much for joining us here on the NeLI Pod. It is great to have you.
Yeah, you're very welcome, and thanks for having me.
So, Judge Kim, I want to start off asking you this question. So, when technology shifts faster than the rules that we have, whether it be the rules of evidence, the rules of civil procedure, how do you define the court's role in shaping discovery? Is it traffic cop? Is it architect? Is it referee? And what principles are anchoring your approach to fairness, proportionality, and obviously the rule of law and justice?
I think, first of all, the federal rules of civil procedure would be our anchor. I mean, I think that judges really have to rely on the current version of the rules, even if the technology is sort of surpassing what the rules contemplated. We do have to sort of stay within the confines of the rules. And in terms of ruling on discovery issues, that really depends heavily on what attorneys are able to offer us. So oftentimes, it may be the first issue that is going to be dealt with by the court. That can sort of set the trend for other courts. There is a huge responsibility on the attorneys to ensure that you do in fact check off all the boxes and you produce the best evidence possible so that you get a good ruling moving forward. I think, it's one thing, you can see the impact that Judge Peck's decision had on TAR. And I think that my decision in Livingston has been cited often in terms of TAR 2.0. So we know that Gen AI review is coming up, and whether attorneys can simply rely on Gen AI in terms of meeting the 26G responsibility, that remains to be seen. So that's a long way of answering that, whether the technology surpasses the rules, we still have the same role of reviewing the evidence before us and making the best possible decision. I mean, one thing we don't do is rewrite the rules. We can't. We don't have that power.
Judge, in your opinions, when you have ruled on issues like this, you've typically given deference to the producing party's reasonable review methods, even when you've had TAR in the mix, like you mentioned with TAR 2.0 and sort of breaking ground on how we look at that. When you look at disputes around the methods that a producing party is using for their review, how do you balance out what they consider to be reasonable with the requesting party's need or desire for transparency and their right or ability to challenge results that are coming out of what might be a reasonable process?
Yeah, that's a great question. So let's start with the old-fashioned way of doing discovery, review, and production. That's when I used to litigate. Everything was paper-driven. You actually went to the boxes and looked through the documents, made copies of the documents that are responsive to the requests. That's how it was done. And no one ever challenged that that was a reasonable method to use. Actually go to the boxes, review the documents. Now it's a little more complicated because we are now using programs where the attorneys may not necessarily understand all the ins and outs and saying, hey, I use this program and this is what it came up with. And can you rely simply on that program and say, I've done my due diligence? I think it depends on the reliability of the program. And um, I kind of go back to the Sedona Principle 6 that defendants are in the best position to figure out how best to collect, review, and produce. And so there has to be some level of deference because especially the producing parties, are usually the defendants, and they're in court unwillingly. They didn't volunteer to be in court. So although there's an asymmetry in information and data, there's also asymmetry in terms of desire to be in this forum. So those things I do take into account. Um, so in terms of the process, as long as defendants, when challenged, of course, as long as when challenged, defendants are able to explain the basis for the process and the reliability of the process, I'm not going to push back too much. Frankly, our discovery system or discovery rules are really based on an honor system. I mean, we don't really do discovery on discovery. So when we have document production, we accept it as complete. We accept the signature of the attorney that he or she did indeed conduct a reasonable inquiry and that the response is complete. Now, I don't know in what context that requesting parties are going to challenge the process unless um, it came out in some other way that defendants use a certain particular process for reviewing and producing. Oftentimes, parties will have protocols, right? So you know the process that is going to be used. But if there is no protocol, I'm curious as to how the requesting parties are going to even learn what system the other side is using. But at the end of the day, it really comes down to reliability. Can the producing parties explain to me in plain English what that process is and why it's reliable? Sometimes they may bring in experts to explain because the attorneys are not well versed in explaining the technology. And I have had situations where experts uh, appear by phone to explain the process.
It's interesting that you said the phrase discovery on discovery. Where is the line for discovery on discovery? You've declined in the past to force disclosure of a search protocol absent specific deficiencies. So what are some of the specific showings that move a request from speculative to warranted?
So there have been times, and this usually happens when somebody's being deposed, right? Um, uh, Documents have been produced, and an employee is being deposed, and it turns out the employee discloses that he used his phone for many of the work messages or on assignment, or the employee used other messaging tools for communicating with others. But discovery responses never included any of those things. Now we have a problem, right? How did you go about finding these responsive documents, and why did you miss out on some of these really simple yet important discovery responses. Now we have to go in and figure out, okay, what process did you use? What keywords did you use? And which custodians did you look at? And so that's going to be the discovery and discovery. And it doesn't happen often, but it does come up from time to time. For me, now, this is one of the unfortunate aspect of federal practice in discovery. Discovery issues are quite discretion. There's a lot of discretion that the court enjoys in passing judgment and rulings on discovery issues. So unfortunately, it's going to be very different depending on your judge. For me, um, I do not I am not in favor of discovery and discovery unless there is solid basis that the producing party may not have complied with Rule 26G. I think that's a good way of understanding when discovery and discovery is necessary.
I want to talk about another aspect that a receiving party can sometimes object to, and that's the form of the production. You mentioned earlier when you started practice, and I'm in the same boat, been in it for a long time. So it was paper and boxes, and when you were producing data, it was pretty simple what form it was going to be in. Now, 20 years later, 25 years later, there are a lot of different forms in which we can produce data, and we also have data coming in so many different forms. It's hard to homogenize certain things. You run into things like modern attachments, or do they want TIFFs or PDFs, whatever it might be. When you run into a dispute like that, how do you decide whether or not form actually matters in a production and when parties should simply move on, take it at what it is, and take usable data for what it is?
Yes. So recently I had an issue come up in a ESI protocol. The parties were able to agree on all aspects of that protocol except for one item. And that item was whether the producing party can go ahead and thread all of the emails so that when they review the email communications, it will be much easier. You have that one single chain to review and decide whether it's responsive and also whether it's privileged. So the producing party wanted to thread all the emails, which would save them a lot of time and then, of course, a lot of money. Plaintiffs objected to this particular format because number one, it's not native, right? And number two, and by the way, this is all public record, so I'm not giving you anything that hasn't been written on or talked about in court. Plaintiffs took the position that when you thread the emails, you're losing a lot of the metadata. And plaintiffs argue that they are able to harness the power of metadata to get other critical information about various witnesses, who might be the most important person to talk to, etc. I'm not going to give you a list because they weren't so much specific in terms of how they were going to use that metadata. But when we talk about form of production, I always go back to the rule, right? And when I said that the federal rules of civil procedure have to be our anchor, I really do mean that. And I think that the rule says, 34 says it's a native format, whatever format you use. And that is not threading the emails, that is not the native format. And so unless there is good reason, and this is where proportionality comes into play. And in the case that I wrote on, the I didn't think at least I wasn't persuaded from the producing party defendant that that the burden of reviewing non-threaded emails is so great that plaintiffs should not be able to harness the metadata for their own use with their own programs. Now, it's still an open issue because I did deny the motion to use threading without prejudice. And if they are able to show me more information about the cost and the burden, I need to sort of weigh that with what benefit are we really getting from that metadata? And that remains to be seen. I don't know whether it's going to be refiled, but we'll see. But that's how I would go ahead and deal with the form of production. I think that it's important to be efficient. I mean, Rule 1 does say, let's go ahead and interpret these rules for efficient adjudication of all claims. So I don't mind that defendants, or I should say, producing party, wants to use the most efficient format and the form of production. I just need a good reason why we should deviate from the default rule.
That's interesting. What do you do then, Judge, when the parties can't agree? I mean, is it really just go back to, let's just go back and take a look at what the rules are? I mean, my thought process here, Judge, is that the way that technology is advancing, and it's advancing so quickly with the various different forms of data that are out there, the metadata may actually make a difference. It's not just an email, right? But it's in other data as well, where the metadata is going to make a difference. Maybe, uh, someone says, "Hey, I only want to give you a load file." Then the other party says, "Well, I don't want to give you that. I don't want that load file. I want the native data." The load file may have metadata that got all messed up in the way that you decided to do it. So the issue of metadata is even more complex than obviously just basic email to CC from, etc. So is it, at the end of the day, just, it's going back to proportionality, or do we have to bring in outside experts in order to testify as to whether or not, we do need all this other metadata? Because I think, to me, it goes beyond just the issue of email threading. I mean, this is ultimately, the parties have to agree on what's going inside of an ESI protocol. Parties have to agree about how they're going to be able to move forward. And there you are sitting at the bench having to decide it. So what goes through your mind, Judge, when
So
this happens?
this all comes down to balancing tests, right? We have to do a cost and benefit analysis. And that's what proportionality standard is in Rule 26B1. I mean, we are told that we need to do the weighing test. But when we weigh, we can't just accept your conclusory argument. Metadata is important. Yes, we know it's important, but how are you going to use it? I need concrete examples how that information is going to be used during the prosecution or defense of this case. So when we talk about burden, I'm still getting briefs where the producing party is saying it's overly burdensome without telling me exactly why it's overly burdensome. I did have one attorney who did a great job of showing burden. So he submitted a declaration from an employee who is going to be responsible for locating the responsive documents. And this declarant actually laid out, detailed the steps that she was taking to find these documents. And she laid out and also timed herself finding one document. And it turns out so many hours were spent to locate this one document. I'm not saying that detailed specificity is always required, but us judges, we do have to have some specificity so that we can use that as a basis to say this particular request is not proportional, or the form that you're asking for, it's just a waste of money. Without specificity, I think that most judges are going to be very reluctant to say the requesting party is not entitled to the information the way they want it. And I think that because it goes back to asymmetry of information. Plaintiffs are they don't have the information that defendants have. And in order to level the playing field, we need to give plaintiffs, or I should say, requesting party, access to that information and the way the plaintiffs can use that information. And that's where this form is coming into play, how the information is actually used. But again, for me, I think the requesting party has to do more than simply say, oh, metadata can be used this way or that way. Tell me how you are going to use that metadata in this particular case. That's the kind of specificity I think the courts are looking for when we are doing the balancing test.
One of the things that you mentioned there, Judge, in your answer was the burden, the amount of effort that's being put into these discovery efforts by a producing party. And one of the tools that we've seen be used by a lot of parties is now 502D orders, which are really designed to protect against incidental production, but sometimes there's a risk of people becoming a little bit complacent. Oh well, it's covered by a 502D, so we don't have to put as much effort into this type of screening. When you look at the concept of 502, excuse me, 502D orders and their application, what do you think is really the level or the standard of good hygiene by a producing party to meet their burden of, we really did what we should have in order for us to be covered by this order?
So I think that 502D is really misunderstood. I think it is just that, produce, and don't worry about waiving privilege. That cuts down on the review that you have to do for privilege um, uh, screening. I think the way I read 502D is that you don't have to be so concerned about producing privileged documents. You can always call those back. There's no uh, minimal effort that you have to make. But I'm not sure that the parties are using 502D. They're not taking advantage of the 502D. And so whenever I get a consent case or if I am referred discovery supervision, the first thing I do is when I issue a scheduling order for written discovery, I include the 502D order in there, letting the parties know that you have this protection. You don't have to worry about waiving your privilege if you disclose. How often do you hear arguments from the producing side? It's going to be overly burdensome because we have to do a manual review for privilege and we have 50,000 documents to go through. I had this come up in an employment discrimination case where the producing party didn't want to produce the documents because they said it was going to cost 400 hours of review to make sure that we have the privileged documents pulled out. And I said, that's perfectly fine. You have the right to go ahead and do a manual review for privilege screening. But I'm not going to then use that cost in doing the cost and benefit analysis because you're doing something that's for your own benefit, at least in my opinion. You have the right, you have the privilege of using 502D, and yet you're not willing to use that. Now, an argument can be made that, we have every right to be reluctant to produce privileged documents, even if you're not waiving privilege, right? So that smoking gun document, albeit privileged, is going to be seen by the other side, and it can have consequences. But I still resort to the rules that we have. Those are the rules that I follow, and when I am doing the balancing test.
Judge, you sat on Rand's tar validation panel, and I'm curious in the courtroom, what are the evidence or metrics that actually persuade you that a tar workflow is defensible? Is it sampling? Is it illusion? Is it calibration? What do you look at? I have a feeling based on your answers already. I feel like I know what it's going to be, but what do you say, Judge?
It's been a while since I actually had a hearing in that one case that dealt with TAR 2.0. I do remember the expert coming in and testifying, going through the process and how the review was going to work and how that particular work was going to be verified. Um, I think it depends on the program that the producing party is using, whatever program that might be. But because each program and platform, they have their own validation process. The key point, though, is that they are actually using those features, right? Um, and during the RAND conference, one of the things that came up is the cost that goes into validating, the cost associated with double checking and whatnot. And is there a way for the industry or among the vendors to come up with some standard that can be followed in each case when you use technology to review documents? But at the end of the day, it has to be plain English information that the expert can tell me that I feel good about the fact that this process is indeed reliable. That's really for me. For me, that's what it comes down to. I don't know that I would necessarily place too much faith in attorneys telling me, because they're just going to be repeating or parroting what the expert said. But many things can get lost in that process. And so I'd rather hear from the experts themselves who are familiar with the platform. And I'm not saying that the attorneys are not familiar. In fact, it's their obligation to be familiar with the platforms. But I much prefer to hear from the experts themselves to get. It's just been my experience. They explain things much better in terms of their own technology.
So, Judge, as Daniel mentioned in our intro to the podcast, you've had a pretty varied career in the legal industry, and from Cook County to the AUSA position, Chief Magistrate Judge, you've seen discovery from a number of different angles and presided over a number of different cases. Do you have a particular role or experience that you feel really shaped your expectations for counsel and how they approach discovery and how they approach cases for you?
So so I've never been in private practice. And so I don't know what it's like to have that pressure of the client saying, why do we need to give away all this information? This is all confidential. It's proprietary. I don't care that there's a lawsuit. Why do I have to give away our store here? When you're in your government practice in terms of discovery, and I'll just kind of focus more on my days as an assistant U.S. attorney representing the U.S. government in civil matters. So my philosophy was, you want it, take it. You know, I just had an open book position, not only because it cuts down on the disputes, but also because I was representing the U.S. government. And I felt that I had an obligation to be open with the other side. But I need to sort of put that in context. Back when I was litigating, we were document driven. So we're not talking, you know, what is it now? Zettabytes of data. I mean, we're not talking that scale. I mean, the amount of data that is out there is just tremendous. So I had a very different practice, but that still stays with me, to the extent that if you want it, take it, do what you want with it. I've got nothing to hide. But I do understand that private practitioners have a very different concern and very different guidelines and pressure from their clients, because to produce everything that the other side wants, it's going to be very expensive, and you don't have the U.S. government paying for it. But aside from that mentality, when I was practicing, there's nothing else that really influences me, other than really, again, going back to the federal rules of civil procedure. I think that one aspect that I do look at that perhaps other judges do not is this idea that although although the requesting party and the producing party should be treated equally, right? They are not in equal position. They are different. One party wants to be in court, the other party does not. I do take that into consideration in terms of assessing burden, in terms of assessing how much burden is reasonable or unduly burdensome.
Judge, one of the things that I really appreciate in this entire episode that we've discussed so far is your desire to make sure that we're following the rules, right? There's very clear from this conversation that if we follow the rules, then we're able to have a much more efficient process. Brandon and I have asked this of other legal practitioners as well, and I'm curious from your perspective, sitting on the bench, what do we do when we want to follow the rules, but when this world of Gen AI, it's very hard to follow the rules when you have evidence brought in front of you and you have no idea whether or not it's real or it's fake. And the idea of being able to authenticate evidence the way that we used to, whether it's a photograph or whether it was metadata on the back of a digital photo. It's very hard to authenticate when you've got a deep fake, and to change the rules, specifically the federal rules of evidence, to authenticate evidence. I believe that's 901, 902. How do we deal with that today? And I have to imagine it makes your job incredibly difficult.
Uh, I don't know that it's going to make my job difficult. I think it's going to make the litigator's job very difficult, because not only do you now have discovery disputes to deal with, I think that during discovery, you are going to have authentication issues to deal with. I can't remember the last time where I tried a case or presided over a trial that we had an authentication issue. It's just not an issue, you know? A document was produced, that's the document. No one questions its authenticity. But with Gen AI produced evidence, it's going to become more challenging. And I think the attorneys are going to have to sort of dig under and figure out, how did you get this evidence? How was it created? And you need to start challenging the process and start challenging the program itself. And of course, what that means is going to be, it's going to be more expensive. I mean, I don't know whether Gen AI in this regard is going to be helpful. But again, going back to what Rand Corporation was trying to do, was to come up with a plan, some standard that everyone can follow. And I hope that smarter people in the room can formulate something or a process system that we can all sort of gravitate towards, in terms of authenticating, in terms of showing reliability, so that we don't have to have these mini trials over authenticity and over reliability. I really do hope that that's the case, but I don't know if anyone is really grappling with this issue of coming up with some standards.
And Judge Daniel just brought up a great point. One of the emerging things that may become a problem in the next several years with the advent of Gen AI, if you were to look into your crystal ball and think next year, years beyond, where do you see the changes in technology really requiring some real effort to get bench bar agreement, getting everybody on the same page as to how we do this process or how we look at this type of evidence? What are those emerging things that you would predict are going to be real topics of discussion and decision over the next couple of years?
Yeah. One thing I'm kind of excited about is the idea of both the requesting producing party using Gen AI in order to get the documents they need to prosecute and to defend. At the end of the day, this whole litigation process is a truth-seeking process. Sometimes we forget that, right? Sometimes we look at it as a way to, it's a process for me to get my favored evidence. But it's really a truth-seeking process. And at the end of the day, whether that process favors the requesting party or the producing party, it is what it is. With the cost of Gen AI going down, and with the level of trust that we may build over time, perhaps Rule 34, you're not going to be detailing documents you want. You're going to be detailing prompts for the program to run. And if the parties can get on board and say, this is the process we're going to take, then whatever gets, whatever is actually produced, you live with that, you know? Now, of course, there are going to be this and that that you need to carve out. For example, privileged documents. Again, I think that there are, I mean, I've never used it, but I have read articles and have seen descriptions of programs that will in fact generate a privilege log. So if we can marry these features together, we can use 34 as a way to deal with all written discovery. Can you imagine a world where we don't have motions to compel? For me, that would be an ideal where producing party and the requesting party agree on these prompts. Now, maybe that's where the motions to compel will be, where the judge has to step in and say, that prompt is overly broad. That prompt is not proportional to the needs of this case. But I think that's my forecast, that's where we're going to go. Rule 34, use of Rule 34 is going to change dramatically.
Well, Judge, it has been a pleasure and a privilege to have you on today. On behalf of Daniel and I and all of our NeLI Pod viewers and listeners, just want to thank you for your time and your insight.
Well, thanks for having me, and thanks for listening to me. Take care.
Anytime.
Thank you, Judge. If you've enjoyed our discussion and want to learn more, don't forget to subscribe to our podcast on your favorite streaming platform. We're here to help you stay on top of the latest trends and developments in eDiscovery.
We'd love to hear your thoughts and questions about today's topic. Reach out to us via our social media channels or email us directly. Your feedback makes our program stronger and more attuned to the topics you care about in the world of legal technology.
Remember, all the resources and insights shared today are aimed at enhancing your practice and understanding of eDiscovery.
Join us next time on NeLI Pod as we continue to bring you expert knowledge and lively discussions. Until then, keep innovating, keep discovering, and keep pushing the boundaries of legal technology. Thank you for listening, and we'll see you next time.